the talk, I'm going to be addressing recent cases on the enforcement of non-compete covenants, and I'll draw out some of the recent themes emerging in the court's treatment of non-competes and applications for injunctive relief, and then Joel will consider some of the alternatives to non-compete covenants. I start with the familiar three-stage test for enforceability of restrictive covenants, and it's just as well that it's a familiar test because I understand that in your printed handout it's very small, too small properly to read. So it's just as well we all know it in our sleep. And the reason I take us back to basics is because the very intense litigation of non-competes and other covenants over the last 15 to 20 years, largely by individuals in the audience, means we now have a near uniform approach to drafting that is more detailed and sophisticated than it's been in the past, with definition sections, backstops, etc. Fewer arguments on the drafting, although time periods are perennial, and the arguments are going instead to the deeper principles of the test. In practice, as we know, most non-competes are litigated at the interim stage. That's often the most valuable remedy for the employer to get an injunction, stops the competitive activity in its tracks, stems and even prevents the damage, and it can disrupt the competitor's strategy. But of course, the employer faces a significant risk that the covenant is struck down at that stage, and then it's left undefended against its competitors' poaching rights. And that risk is heightened by the fact that even where the covenant is deemed likely reasonable, the employer must still satisfy the test for the grant of interim relief. Again, it's a familiar test, but worth retreading, classically formulated as 3 stages in American cyanamid. But in it's a springboard case, Create Financial, the judge there set it out in 4 stages. Again, so important, I thought I'd put it on the slide in full. You can see it on the screen, and the point that I particularly want to highlight is it becomes a 4-stage test rather than 3 stages, because the judge separates out adequacy of damages to the claimant on the one hand and then to the defendant on the other hand, and emphasises that for the defendant's damages to be an adequate remedy, it must be both that the claimant will be able to pay on any award at trial and that the defendant's damages are quantifiable. Briefly, let me mention underlying merits. These can be considered at the balanced convenience stage if the trial will not take place before the expiry of the restraint. That's the Lansing-Linder distinction. So, turning then to adequacy of damages. The conventional approach has been to view adequacy of damages as really only an issue for the defendant if the claimant wouldn't be good for the money. As long as the claimant could pay and was committed on the cross-undertaking, then there was no further inquiry by the court. It would tend to assume that damages were simply adequate for the defendant. It's become more common in recent years for defendants to argue the enforcement of non-compete covenants would cause hardship to them, for which damages are not an adequate remedy. Initially, there was judicial scepticism. In both the Yeo and the Alley case, the judges were critical of limited evidence provided by defendants and said that proper and cogent evidence would be required. In the Carmichael case, a case in which PwC sought to enforce the non-compete in its LLP agreement, the judge took into account that the defendant had been paid a substantial sum on his garden leave at a point when he knew the LLP would try and hold him to the non-compete. In effect, he should have set that aside to make up for any financial constraints during the period of restraint. These were all arguments that I made in Planon, that as part of the defendant's planned resignation and move to a competitor, he could and should have set money aside to cover a period of work, period out of work when the non-compete was enforced against him. That argument did not prevail. Planon represents a sea change in how adequacy of damages is considered in relation to defendants. There, the Court of Appeal accepted that the defendant would lose his employment at the new company if the non-compete was enforced, and it was also willing to accept that he would face financial difficulties with only the witness statement as evidence, no supporting documents, and no dive into the figures. In the passage that I cite on the slide from Lord Justice Bean, he went as far as to say that it's unrealistic to argue damages could be adequate except in the case of a wealthy defendant or where the period of restraint is being paid for by the old employer. Lord Justice Bean went on to note that the fact that the non-compete covenant contained a limitation to the kinds of duties that Gilligan had done in his previous employment was no help to Planon. Of course, that limitation was inserted in order to make the non-compete reasonable, but we weren't able to rely on it, all justice being said, because it would be too risky for him to go and work in the competitor company and say that he was doing non-competitive duties when he was under a penal notice. So unsurprisingly, since Planon, the point has been taken more frequently, and on the slide I draw out two particularly interesting recent cases. And note just how well remunerated the defendant is in Gilbert Roth, with a salary of 200k and benefits on top. The defendant in that case, though, had a lot of evidence that he couldn't get any other job other than a specialist role with a competitor. In Sparta, the argument also succeeded. There was a real risk identified that the defendant would lose his job with the new company, and a sole income provider with child with special needs, that would cause hardship that damages couldn't compensate. An additional argument was made in relation to the defendant's future employment prospects being affected. It was said for the defendant that because he worked in a specialist field, his skills would atrophy if he was forced into a period of non-specialist work. And the judge accepted that enforcing the non-compete would have that impact, would make him a less desirable recruit after the expiry of the period, and that couldn't be compensated. Ultimately, the judge said the assessment was about balance and proportionality. Together with an assessment of the limited threat to the employer, the judge found that the balance of convenience favoured the defendant. In Sparta, there was an additional argument that the impact of doing non-specialist work, being forced to do non-specialist work by the enforcement of the non-compete, would have an impact on the defendant's well-being and his mental health, the loss of congenial employment for that period of time. And the judge didn't accept in that case that the mental health impacts were of any weight. But it didn't find that it couldn't be in other cases. And I suggest it's a sign of just how far the argument is moving in favour of defendants, that these sorts of factors are entering the frame at all. Planon has also bolstered arguments on delay and changes to the status quo. And in the interest of time, I will say simply, now that non-competes are disfavoured in the courts, it is even more important to ensure that clients are acting promptly in order not to give the other side an easy point to score. While drafting conventions are now well established and non-competes are often taken off the peg, there are still pitfalls for employers who use non-competes without tailoring them to the particular employee and their role. And one reason for that is because, counterintuitively to clients, reasonableness is to be assessed at the time that the contract is entered into and not the time that the contract is being enforced. And that principle was applied to chilling effect in Quilter, where the defendant argued successfully that the non-compete was unreasonable in the context of her junior status. She was on a probation period which was extendable at will by the employer, and for the duration of her probation she had a short notice period of 2 weeks, as against a non-compete of 9 months. And from that case there followed a rash of defendants who argued that a short notice period would of itself make their non-compete unreasonable. Now, several cases have clarified that the notice period is one factor amongst many. It's not necessarily determinative. And in Sparta, again, the defendant was on a 6-month probation period with 1 week's notice. The defendant had already agreed to abide by a 6-month restrictive covenant non-compete in the employment contract, and at court the employer sought to go for the 12-month non-compete in the investment agreement. And the judge simply deemed the length of notice an additional factor in what he described as the overall and holistic assessment of reasonableness of the duration of restraint. I suggest there are 2 points that arise from the approach taken in Sparta. The first is a holistic assessment of the contract itself, not just looking at the terms of the non-compete, but how they sit in the wider contractual remit. But second of all, the judge took into account the notice period from the employment contract in considering the non-compete in the investment agreement. So he had regard not just to the holistic position of the contract, but the whole of the contractual matrix in which the employer and employee were operating. Quantum is a seminal decision of the Court of Appeal considering the whole of the restraint of trade doctrine. It was a commercial agreement case for business services, where the judgment is relevant to restraints arising in any form of agreement. The factors at play in assessing reasonableness were considered at a high level in Lady Justice Carr's judgment, and she identified factors that will fall to be considered. And I want to pluck out of the factors that are listed there inequality of bargaining power, consideration, and compensation as being particularly interesting for us to examine how they will impact the advice we give as employment lawyers. It's well established that in employment contracts, non-competes are scrutinised more closely than in commercial agreements. And the justification for this is the equality of bargaining power presumed to exist between commercial parties, so that the public policy interest is in upholding the parties' freedom of contract. The courts now view agreements as being on a spectrum. At one end will be business agreements, at the other end, small-scale shareholder agreements that are treated as akin to employment. And the non-competes in those agreements will be scrutinised more closely as an employment contract would. The spectrum approach has opened up arguments that ostensibly commercial agreements should be treated as akin to employment agreements. And this begs the question, can the reverse be said? Is it possible that there are circumstances in which an employment contract ought to be treated with similar leniency to a shareholder or business sale agreement? In Credico, a franchise case, Sir Patrick Elias said that the courts shouldn't agonise when considering non-competes on where to position the contract in the spectrum. Rather, the real issue is whether the judge takes into account the factors which show the extent of inequality of bargaining power. And this suggests the correct approach is a factorial analysis, i.e. the court should go through the factors identified in quantum rather than be hidebound by the form of contract or its placement on the spectrum. In my view, given the recent trend for the courts to act protectively of employers and the increasing recognition of the significance of unequal bargaining power, it may be an argument that's unlikely to succeed in anything other than an exceptional case. But that's not to say that exceptional cases won't exist. The sorts of factors that may suggest material bargaining power on the part of the employee, I suggest, are whether the employee has had access to legal advice and legal representation through the process of negotiation, and if the employee has pushed back on the scope of restraint, for example, negotiated a carve-out in respect of particular customers. Quantum also identifies consideration as a relevant factor and identifies it as relevant twice. First of all, the fact of consideration, which of course we know from Reviews and Sendall must exist in order for the covenants to bind. But second of all, the level of compensation is identified as being possibly relevant. And Lady Justice Carr, in that part of her judgment, refers to the decision in Panayiotou, the George Michael and Sony case, where compensation was deemed to be so substantial that it was in his interests to agree the restraint, and that was a factor in play. But again, what about the reverse, where there's no particular payment for the non-compete clause? And clients increasingly ask me, as I'm sure they do you, whether they should offer to continue to pay during the period of restraint in order to persuade the employee, and if not them, then the court, to enforce the non-compete. And that certainly neutralises arguments on the adequacy of damages and hardship, as Justice Bean set out. However, in quantum, compensation is identified as a factor in the assessment of reasonableness. And of course, reasonableness is to be determined not at the point of enforcement and arguing the injunction, but at the time that the contract is entered into. Does that raise a question whether, in some cases, the safest thing to do in drafting the non-compete is to include compensation for it at that stage? Finally, I want to finish with an observation on Harcus Sinclair. In this case, the Supreme Court considered the underpinnings of the restraint of trade doctrine. Again, it was a commercial context, with which I'm sure you're very familiar, a non-disclosure agreement which contemplated the potential for a future litigation funding agreement. And one of the questions that the Supreme Court asked as part of the assessment of reasonableness was whether the restriction was commensurate. And again, I've set up paragraph 72 on the slide because it appears to add this as an additional requirement to that three-stage TFS test we looked at the start. If legitimate interests are established, well, that's TFS step 2, and then goes no further than is reasonably necessary, Well, that's TFS step 3. And then we appear to have a further step, that the restriction must be commensurate with the benefits under the contract. I suggest there are 2 possible readings of this requirement. The first is that it doesn't have much impact for us as employment lawyers because employment contracts always have a balance of duties and obligations. By contrast, some commercial agreements may be entirely one-sided with nothing for one party to do at all. But the second reading of this is that, in fact, the courts must examine the balance of benefits and obligations as part of considering the reasonableness of the covenants. Isn't that exactly the sort of analysis that was taking place in Quilter with the notice period, and in Carmichael looking at pay during garden leave, and in Sparta looking at the terms of the employment agreement and the relationship to the investment agreement? And the judges in those cases talk about proportionality, they talk about holistic assessments. And I wonder truly what is the difference between that and looking at whether the benefits are commensurate. Whatever the answer, it's clear that the courts will no longer look only at the business case for a non-compete. They will also have regard to the impact and experience on the employee if the non-compete is enforced. And in short, employers should prepare for this when they are applying for their injunctions. I'm going to hand over now to Joel to discuss what alternatives there are for employers.
So, you have a director who would present a threat to your client's business if they move to a competitor due to their knowledge, their skill, or client connections. And you're strategizing about how to stop them from joining the competitor. Your client didn't hire Lucy or take her advice in respect of the terms of service because either there is no non-compete or it's likely that the non-compete is unenforceable. So what do? There may be some creative solutions to the conundrum, and we offer 3 here. Now, obviously, you all know what a garden leave clause is. This isn't a golden example, but it's a short example, real-life example, which serves the purposes of the presentation. There'll be usually a clause that states that it's activated on notice. There'll be a down tools provision or no requirement to work or exclusion from the workplace. There'll be exceptions to the down tools provision, in this case for handover. Also, there'll be a provision that protects employees from poaching and also clients from solicitation and dealing. I would also note clause 4.1 there, that the terms of the employment contract are still in force, and that would, one would hope, include express terms of fidelity and confidentiality, and failing that, implied terms. Of course, what would be nice is if we had those expressly stated within the garden leave clause as well. And these clauses together then prevent the employee from working for a competitor. So notice is given, the employee is placed on garden leave, and because their employment is ongoing, albeit that they're on garden leave, the employer effectively gets a non-compete for the length of the employee's notice period. Simple. Well, not quite. The long-standing rule enshrined in Talaka 1992, section 236, gives us a tension with the contractual provisions. The court cannot force an employee to work under a contract of employment. And so on the one hand, we have the contractual provision agreed by the parties that there is a right to notice. And on the other hand, the principle that prevents courts from forcing people to work, which arguably renders the right to notice unenforceable and therefore not really a right at all. Enter Provident Financial Group and Hayward, in which the Court of Appeal held that preventing an employee from working for a competitor is not quite the same as forcing the employee to work for their current employer, although it could be if the circumstances are right. For instance, the employee needed to work for the competitor to support themselves financially during the notice period, or if there is a skills issue where the skills are at risk of atrophying during the notice period. But in that case, the employer undertook to pay the employee full salary and full benefits during the garden leave notice period. And the period was only 3 months. The employee was an accountant, and I guess 3 months isn't so long for an accountant to be out of the game. So held Lord Justice Taylor in any event. There was a warning from Lord Justice Dillon, which was that longer periods might well see an atrophying of skills. And I think to our present era, where there are influences abound, even amongst lawyers, I'm not sure about accountants, but certainly amongst lawyers, we might see that lengthy periods out of the game will affect reputation and therefore appear oppressive. So how does one enforce garden leave provisions in practice? Well, we're entering interim injunction territory. American Cyanamide and Lucy has done the hard work of going through that. I won't repeat, save to note an important feature taken from Hayward, which is that when we're giving cross undertakings, we'd expect to see a cross undertaking to pay the employee during the period of notice and give them their full benefits. I say expect, there's always caveats, there's always exceptions. Sunrise Brokers gives us that we are, in that case, it's not a garden leave case, but in that case, Rogers refused to work his notice period. Sunrise said, fine, we're not going to pay you. And both the High Court and the Court of Appeal said Sunrise were well within their rights to do so because, of course, Rogers couldn't be said to be ready, willing and able to work. But Belt and Brace's default position, give the undertaking to pay and provide benefits during the notice period. Per Hayward, it might be thought that obtaining an injunction for garden leave of 12 months is not going to work. But there are 2 points on this. First of all, there's been a sweep of case law which suggests that 12 months is an acceptable period of time for garden leave. Credit Suisse, there the court held that actually only 6 months would do. 12 months was too long. But there are some comments that hint at 12 months being potentially acceptable. And there's another case, Holiday, which I'll come back to in a moment, in which injunctive relief was given for the full 12-month period. But even if 12 months is too long, we come to a set of cases, such as the case of Eaglestone, where garden leave was 20 weeks and injunction was only granted for 3 months. Because on the evidence, 20 weeks was not necessary to protect the employer's interest. And here we see this second point on flexibility, that even if it's too long, what the court can do on an injunction is shorten the period of injunction. And here we see an advantage as compared to the non-competes that Lucy was talking about. With non-competes, you've got a binary, right? If the non-compete is wide and the period of non-compete is wider than is reasonably necessary to protect the business interest, then you're not going to get your injunction. If it's not, then other factors come into play and discretion is deployed. However, with garden leave, if the garden leave period is excessive, that doesn't mean that you lose on the injunction. The court still has wiggle room to shorten the period of the injunction, so it doesn't need to match the period of leave. Another aspect or another bit of flexibility that garden leave injunctions provide us with is that you don't necessarily need a garden leave clause at all. We see from the case of William Hill and Tucker that very often there will be a right to work implied within the employment contract if it's not expressly stated, and we get that from construction of the terms. The post might be unique, the skills might be of such a kind that they can't be allowed to atrophy. But there are other cases, the case of Christie, for example, where those circumstances aren't in play, the post isn't unique. And so what we end up with is no right to work, and the employer is free to place the employee on garden leave. Again, belt and braces, the advice is put a garden leave clause provision in there. Don't rely on case law to make your garden leave lawful. But there may be limits on flexibility. The older cases, Tucker, which I've already mentioned, Symbian, point to the application of the restraint of trade doctrine even during the lifetime of the contract for services. But in Finn and Holiday, I did say we'd return to that case, Mrs. Justice Simler expressly stated that the restraint of trade doctrine will not apply during the currency of the employment relationship. However, Simler stated that judges should bear in mind the principles of the restraint of trade doctrine when they're exercising their discretion to grant an injunction. And here we arrive at a problem. If the restraint of trade doctrine doesn't apply during the currency of the employment contract, and garden leave is part of the employment contract, it's within the currency of the employment relationship, then why on earth should judges have recourse to the restraint of trade doctrine when they're exercising their discretion? One point further, is it really realistic to say that a judge is going to find that the garden leave provision, for whatever reason, the period or wording of it, is wider than is reasonably necessary to protect the legitimate business interest, but then we'll go on to say, but I still exercise my discretion to grant the injunction? And the answer is likely not. I provide a case there, BGC Services, where it looks like restraint of trade doctrine was directly applied. It's not really guidance, it's actually a rule that is determinative of the garden leave injunction. So maybe garden leave injunctions don't quite get us around the issues with non-competes. What else might there be? Well, the second tool is to set a minimum term for employment, or to restrict when and how notice can be given. And we see that most commonly in sports cases. I've put up a few popular ones there, or ones that are well known. And perhaps more on the nose, we have a recent case, Hine Solicitors and Jones and Blazer Mill. Lucy was actually acting for the successful Ms. Jones, so I'll keep the summary brief lest I get something wrong. Jones worked as a solicitor for Hine, handed in her 3 months' notice, and then joined Blazer Mills. It seems Hine may not have initially challenged the notice, although this was a matter to be determined at trial. Later, Hine challenged the notice on the basis that there was a contractual minimum term of 3 years before notice could be given, and notice was given with 2 years left to run on that contractual minimum period. Hine initially applied for an injunction to prevent Jones from working for Blazer Mills. Pretty bold move. Withdrew the application and replaced it with an injunction that sought to effectively prevent solicitation and dealing with Hine clients for the 2 years plus 3 months notice that was left on the contract. American cyanamide was applied. Was there a serious issue to be tried? Yes, said the court, although that's notwithstanding my learned friend's creative argument that actually the statutory right to notice invalidates these kind of minimum term provisions. Hopefully we'll see that played out at some point in the near future. Were damages an adequate remedy? No. Undertakings were given, though. And it all came down to the balance of convenience and exercise of discretion. And here again, restraint of trade rears its head. It was accepted by Mr. Justice Constable that the doctrine applied. And in this case, legitimate business aim or interest was not proven because there was no evidence that Jones was in fact looking to solicit clients or deal with clients. So no injunction granted. Again, perhaps we don't get away from the restraint of trade doctrine after all. Finally, really a bit of a bonus because of its particular circumstances, but we have the Dormer and Bateman springboard injunction. As with all springboards, in essence, an interim injunction which seeks to prevent an ongoing, unlawful, acquired, unfair advantage. In this case, a team move in which the instigator had restrictive covenants and then sought to poach other employees and move them away from the employer. I talk about the instigator because it was only the instigator that had the restrictive covenants in the contract. The other employees gave notice lawfully, employment terminated, apparently lawfully, or at least in accordance with the terms of the contract, had no restrictions within their contract. Yet, the court granted an injunction in the terms of the covenants that were in the instigator's contract. And so arguably what we have here is the court imposing restrictive covenants in the contracts of employees where those restrictive covenants didn't exist in the first place. Circumstances for this type of injunction must be just right. It seems that whether you can impose, in effect, a non-compete regardless of an enforceable covenant or the existence of an enforceable covenant is going to depend on whether you can convince the court to exercise its discretion in a manner which isn't confined by the restraint of trade doctrine. Lucy and I would be interested to hear whether you agree, and also take any questions when we meet for drinks later. I mentioned fidelity and confidentiality when talking about garden leave injunctions, and they lie at the heart of it. Happily, Niran and Sophia are on next to provide insight into confidentiality, although I believe in a quite different context. Thank you.